information about the defendant's, not only his defense of heat of passion, but also details about the killings. It was very apparent to me in reading the transcripts and listening to those calls that the defendant provided this information. There was one particular quote from Mr. Edwards. First of all, Mr. Edwards was arguing to his wife that, oh, his wife and the other man were inside his house, meaning the defendant's house, as if that was some kind of excuse or justification for killing. Mr. Edwards relayed to his wife that the defendant's wife and the other man were doing drugs inside the apartment. That is not public knowledge. That is not even the truth. That is information that, besides SDPD knowing about a potential bag of cocaine, presumably at the scene, the only other person that had information about drugs at the crime scene was the defendant. Not Mr. Edwards, not anything Mr. Edwards heard on TV or read in the newspaper. That was nowhere in any of the media. So the information that Mr. Edwards had about any potential drugs at the scene came from the defendant. The defendant is the only person that had that information. So to say that Mr. Edwards and the defendant never had a conversation, that is not apparent to me. That is still not apparent in those calls. Mr. Edwards never said in either of those jail calls that he had never met the defendant during his whole time in jail. Mr. Edwards never said, I have never spoken to the TikTok killer or the defendant at any point in time in jail. All he said during those calls was that the defendant was in the hole that month. So maybe he didn't have a conversation with the defendant that month. But there is nothing in those calls that indicates that the defendant had never had a conversation with Mr. Edwards. So based on all the information contained in the calls, I certainly had a firm belief that the defendant provided that information. And when the defendant is testifying in a first-degree murder case and has a heat of passion defense and is testifying that he felt either badly about what he did, that he was sorry, or that he didn't mean to do it, he testified that he didn't even realize he shot Anna. When the defendant is making all those statements during his testimony, it is certainly relevant for the prosecutor to ask him questions on cross-examination that go towards his lack of remorse. And the fact that he was bragging to inmates, making statements to inmates about killing Anna and Ray or killing his bitch and the man she was cheating with, the kinds of statements that I heard in those jail calls, it is certainly very relevant for me to ask those questions on cross-examination. Because that shows the defendant did not have remorse for what he did. It wasn't in the heat of the moment. It was planned, and then he's bragging to inmates about it. I limited my inquiry to 2 questions, and then I moved on. I didn't argue it further. I didn't even argue it in closing. Mr. Edwards was in jail for a murder case as well. I'm not going to bring in another suspected murderer to testify in a case where there's overwhelming evidence of the defendant's guilt. The prosecution can elect what witnesses it will call or not, and that's what I did in this case. The defendant, his response was certainly showing consciousness of guilt. When I asked him, did you ever brag to Mr. Edwards, his response should have just been no. If he really never had a conversation with Brian Edwards or any inmate in jail about the killings, his response would have just been no. That was not his response. He had an outburst. He told me, is this some kind of jail informant that you're asking me about? That shows his guilt in the fact that he knows he made these statements to inmates in jail. And so it's perfectly reasonable for me to ask those questions.
All right, let me make something clear right now.
I'm sorry, sir.
If there's any disturbance, you will be put outside, all right? That happens only once. It's happened now. It will not happen again. And that includes you, Mr. Baldwin. I don't want. Thank you. Go ahead.
Thank you. The defense cited numerous cases in their brief without the facts, and those facts are not the same scenario here. The defendant cited just very briefly the case of People versus Centeno, a case where the prosecutor argued to the jury a misleading standard of proof in the case. That did not happen here. I never argued an improper standard of proof. The defense cited People versus Force, a case where the prosecutor made a comment to the defense attorney that, oh, I may charge your client with perjury if he testifies inconsistently. So the defendant in that case did not testify during that trial. That did not happen here. I didn't raise any perjury charges. The defendant was able to testify fully for 3 days, showing his side of the story. So the factual scenarios in those cases cited by the defense in their moving papers are completely different than the factual situation here. The other cases cited were People versus Fasaro and People versus Jasso. Those cases were not overturned. New trials were not granted in those cases. The court may have found misconduct for arguments by the prosecutor. However, it was harmless error and those cases were not overturned. The People in my moving papers, I cited People versus Watkins. That is a case with a very similar factual scenario to this one. In that case, the prosecutor asked the defendant on cross-examination a question about him laughing and carrying on outside the presence of the jury. That question was objected to, it was sustained. However, the court ruled in that case there was no misconduct based on the prosecutor having a good faith belief in asking a question that explores the remorse of a defendant for a killing. That is similar to what happened here. I was asking questions to explore the defendant's remorse and the fact that this was not a heat of passion case, that it was a planned killing. So there was no misconduct in this case. I know the defense brought up that the court also committed error. That was not the case here. If the court doesn't believe that there is misconduct, which there was not here, then the court is not required to instruct the jury that there was misconduct. So the court did not commit error in that sense. The court did offer a remedy to the defense, which was striking the questions and the answers, and the defense chose strategically not to do that because the defense wanted to be able to ask Mr. Boulevard further questions on redirect and to be able to argue things in closing, which is what she did. And so the defense can now not come in here and say that there was not a proper remedy by the court when she chose not to take that. The court also has to find that there would be prejudice to the defendant, or that there would be a more favorable outcome if those questions had not been asked. And neither of those exist here. There was no prejudice in asking the defendant 2 questions that he was able to explain on his own, and the jury is left to either believe him or not believe him. That is true of all of the questions asked of him and his testimony in general. There would not have been a more favorable outcome here. This is a case where there was overwhelming evidence of the defendant's guilt, and that was shown through his testimony, through the crime scene, through his admissions, through video evidence, through audio evidence, through evidence in his vehicle, social media. There was an abundant amount of evidence proving the defendant's guilt. And so 1 or 2 questions asked of him on cross-examination that does not prejudice him. He certainly received a fair trial in this case. He was able to fully testify and tell his side of the story, and there would not have been a more favorable outcome. What I also attached to my opposition was a declaration from District Attorney Investigator Elliot Schaefer. That's S-H-A-F-F-E-R. And in that declaration, Mr. Schaefer reiterated the comments made by the jury foreperson after the verdicts. And the jury foreperson indicated that the jury looked at all of the evidence in this case,